Thank you very much, and let me extend my welcome as well to everyone here, and my thanks to all who have been noted before. And thank you, Celeste, and your staff for such great support in helping us put together this retrospective and perspective on the Quiet Revolution. Do make no mistake, however, the Quiet Revolution and land use control may have two names on it, but the idea came from Fred Bosselman, the formulation came from Fred Bosselman, and the support of the President's Council on Environmental Quality was obtained by Fred Bosselman. I was a newly minted associate, and I was delighted to work with who was then and still is now undoubtedly the most innovative person in this field that I have ever met. And I'm just delighted that Fred is here and we'll be able to do a retrospective on it at the end. Although the Quiet Revolution, it all began in Hawaii, only one state really undertook anything remotely resembling true statewide land use controls, and that was Oregon, and still is Oregon. Oregon's had a lot more press than Hawaii over the years over one thing and another. We're delighted to have with us today Ed Sullivan, a practitioner from a law firm in Oregon, who, as to paraphrase Mark Twain, he knows all there is to know about Oregon, and we know the rest. He has been in the field for a long, long time. He is one of the few practitioners that actually manages to take a sabbatical every once in a while, and does things on his sabbatical like go to Spain, get tutored in a classical language, and then read works in its original. A true Renaissance man. Please welcome Ed Sullivan.
Good morning. Historians sometimes flatter themselves that their post hoc categorization of phenomena actually explains significant events and movements. We know by a closer examination that significant things such as the Oregon Land Use Program are actually the product of many sources. There's a background in the political and social history of the state. There's the happenstance of circumstance, such as the Bosselman and Cayley's work and its influence in Oregon, which I'm going to talk about today. And there's just dumb luck. In 1973, the only year that our planning program could have passed, we were faced with the environmental movement, we were faced with a reform movement, and something happened. Something magical happened that year, and we're lucky enough to still have it. What was the work of Bosselman and Cayley's that so influenced Oregon? There were three issues, I think, that make a significant impact on our program from this book. First of all, the role of the plan. First of all, to have a plan was a fairly radical thing in 1971. And to have a plan have meaning was also fairly significant. A second thing was the role of the environment. That radical environmentalist, Richard Nixon, dealt with the Coastal Zone Management Act, the first comprehensive air and water quality standards, the Coastal Zone Management Act, and other things, the Council for Environmental Quality, EPA, and the like. Those were significant currents that occurred in that time. And then finally, a third influence of the book had to do with a significant state participation in the planning and regulatory process. Those three things out of the Bosselman and Cayley's work were significant to Oregon. We weren't the first. David Cayley's mentioned that Hawaii started in 1961 and has its program elaborated upon much further today. Florida was a year ahead of us in 1972. Some parts of that program remain today, significant parts. But in 1973, Oregon undertook the work of a statewide planning program. That's where I'm going to go today. For Oregon's land use background, we had until 1960 or so, just about the same approach to land use as everybody else. We didn't adopt either the Standard Planning Enabling Act or the Standard Zoning Enabling Act, but we had close enough analogs. And those analogs delegated all authority to local governments to undertake planning if they wanted to, and zoning, again, if they wanted to. But in 1947, we enabled counties in Oregon to plan, and we did something a little different than the standard acts. We required that zoning be in accordance with a development pattern, usually a big map on the wall with broad land use categories. In 1963, we changed that to use the word comprehensive plan, so that zoning was required to be based upon some external document which set policy. A big difference. Even though our city enabling legislation from 1919 talked about being in accordance with a comprehensive plan, it really was honored in the breach. Many cities in Oregon just didn't have plans, or if they did, they weren't given any respect. In 1961, we undertook the work of merging our farm policy for preservation of agricultural lands with our tax policy, creating exclusive farm use zones, where if you farmed within those zones, your land would be appraised at not its highest and best use, but at its use as farmland, a big boon for farmers. And in 1969, we took the radical step of legislatively requiring every city and county in the state to undertake planning and zoning. Now, it didn't work out that way. It wasn't done. So in 1973, after reading Bosselman and Kelly's, our legislature undertook the work of passing Senate Bill 100, which required a state participation in our planning system, required every city and county, those are the only two local governments in the state, to undertake planning and zoning, and to consider the environment as part of that planning process. We also had at that time the Fasano and Baker cases, which required us to take a look at rezoning as a quasi-judicial act. What a big difference in looking at rezoning, not as legislatively required, but as a trial-type proceeding analogous to a contested case. And as a result of the Bosselman and Kelly's work, we had Quiet Revolution, which was read by the father of Oregon land use planning, Hector McPherson, in formulating Senate Bill 100. We had Fred Bosselman's work in the Model Land Development Code for the American Law Institute. And we had, in that same year of 1973, Bosselman, Kelly's, and Banta's work on the taking issue, all of which made it a lot more comfortable for us to undertake the program. 1973 was a magical year. It was a year in which farmers got to the legislature and said that if you don't want our land paved over, you better do something about a statewide planning program. And we did. Let me give you some of the characteristics of our program as they evolved over the years. First of all, we required planning and zoning. We had teeth to plans. Any zoning or any quasi-judicial action relating to zoning had to be consistent with the plan, and there were consequences of failure to plan. The state could withhold money. The state could undertake the planning and regulation for the local government. Nobody wanted that to be done, especially the state. There were state policies that were enacted. We call them statewide planning goals. There are 19 of them, and they relate to everything from the planning process to natural resource conservation to urban policy to special areas of the state such as the coast. We have a statewide planning agency, the Land Conservation and Development Commission, otherwise lovely known as LCDC, to formulate those statewide planning goals, not by the legislature, but by this agency, and to enforce them through the acknowledgement, through the certification of local plans and regulations as consistent with the goals. Lacking that, local governments had to make findings showing conformity to their own local plan and to these broad statewide planning goals, which local governments did not like at all. We had a process of appeals directly either to the courts or to LCDC on goal issues, so as to give that program some teeth. We had enforcement through enforcement orders with withholding of funds or doing planning. And we also had a group that was formed shortly after Senate Bill 100 was passed called 1,000 Friends of Oregon, which acted as an enforcement, a public interest enforcement group, and has been copied around the country. We also dealt with what we call life after nirvana. After plans were acknowledged as complying with the goals, you had to deal with what happened later with changing times, changing circumstances, changing policies. And we've done that through something called periodic review, by which plans are looked at every 5 to 15 years to assure continued compliance with the goals, and post-acknowledgement plan amendments, where you have individual changes in your plan, in the code, or even changes in the zoning map, where LCDC is given notice, can intervene, and these notices are available to everybody if they want to participate in the local process. And we made a deal in our statewide planning policy, and the deal was that we would conserve rural lands outside urban growth boundaries if they had farm and forest soils of good quality. And that's most of the land, non-federal land in Oregon, outside of urban growth boundaries. And those areas have been placed in farm and forest zones with a fairly high minimum lot size and with restricted alternative uses that could be made of them. And as a result of that conservation, we intensified the uses that could be done within urban growth boundaries. We dealt with higher densities and intensities of uses. We concentrated our resources for transportation, public facilities and services, and the like within those urban growth boundaries. And in the Portland metropolitan area, we formed an entity called Metro, which took over the urban growth boundary responsibilities for the 3 counties and 24 cities within that urban growth boundary, and actually was a mini LCDC with its own policies and its own acknowledgement process and its own enforcement process. Portland was much more amenable to that than many parts of the rest of the state. Let me talk to you a little bit about the issues that have arisen in our program. It's not been without concern. It's not been without challenge. The fact that we had a statewide planning program enabled Congress to pass the Columbia River Gorge Protection Act that applied to 6 counties on either side of the Columbia River just outside Portland. Allowed for a planning process, allowed for an appeals process, and generally preserves the view of the gorge area for people who pass through it. We've established minimum lot sizes in farm and forest zones. We have, I think, the largest minimum lot size in the nation, 80 acres for farm lands and for forest lands, and 160 acres for rangeland in eastern Oregon, statewide, part of the bargain. We've dealt with destination resorts, big issue in Oregon, so that we have these areas outside urban growth boundaries where people can, tourists can go, where we can take advantage of our natural resources. We have a regional problem-solving process so that cities and counties that don't get along get into a process and the results of that process go to LCDC for review and for acknowledgement. One of the problems that we've had with the system, though, is that we have not looked enough at its capability, its enforcement, and its policy. We had a few years ago something called the Big Look, which was supposed to be a review, a comprehensive review of our system, and it really didn't do a very good job, and we sorely need that review again. And of course, I think most of you who are in land use know about our measures 37 and 49, an opportunity to get at the system from behind by making an argument that the system was not fair and that government, whoever government was, should be responsible for payment to property owners for the incremental difference in value caused by land use regulations. That was a bad deal. It did pass. It quickly got sticker shock when people began looking at the alternatives, which were payment, which was almost never done, or waiving the regulations that were subsequently imposed after the property owner took the property, and allowing for billboards, for shopping centers where those phenomena wouldn't be allowed otherwise. That sticker shock resulted in Measure 49, which allowed for 1 to 3 houses to be built, which was the real problem and the genesis of the dispute in rural areas, to be built in certain circumstances. And even though the problem right now has gone away, it's out there for us to look at. Finally, I want to talk about some problems with our system. There is difficulty in Paradise, and we have had to deal with a number of tough issues. First of all, everybody goes to the legislature. When you have a top-down system, everybody tries to influence. Our legislature, which met every 2 years until last year, now meets every year. So our program is always up for rejiggering. Number two, we've had 2 very bad land use measures passed. Measure 7, which failed in the courts, and Measure 37, which dealt with compensation, just compensation to landowners for the loss of value by planning and zoning. That has a very seductive value to voters who don't know enough about the system. And even though we've repaired it, it's out there as an issue for us to deal with in the future. Thirdly, we have an issue when cities don't want to grow. We have a city in the Portland metro area called Damascus. And Damascus was put inside the metropolitan urban growth boundary, but decided it did not want to have high-density uses. It did not want to have intensive uses. And we really, even though we have the tools to use it, to make that happen, the state and metro are reluctant to do that. And what do you do when somebody refuses to grow, refuses to take up their part of the growth that we require otherwise? Money's a problem. We copied California and passed a tax limitation, property tax limitation. And as a result, the legislature diverts much of state funding from the income tax to fund schools. We don't have a sales tax in Oregon. So that puts us up against the wall in trying to decide where our money goes. And when we have a downturn, as we've had in the last couple of years, what do you put your money into, cops or planning? You know the answer to that. We also have a problem with not reviewing our system entirely and looking at where we're going. We don't have a lot of reporting that's done. We don't have a lot of program monitoring that's done. And we don't have really, aside from the goals, a centrally directed state land use policy for human settlements, for the influx which we expect of climate refugees from other parts of the country coming to us and more than doubling our population in the next 20 years. In conclusion, there will be no frontal assault on the Oregon system that will pass the voters. What may pass are things like Measure 37, where you have an equity sound bite that might convince the voters to do something different. But a frontal assault will not work. We have continuing problems with funding our program. And our biggest problem is the incremental chipping away at that program by the legislature. We're not going to have a radical change as Florida has had, but we will have small things, more rural dwellings outside urban growth boundaries. We have 52 non-farm uses allowed in our farm zone, and that number increases with every legislative session. So we've got our own problems. We're doing reasonably well, but it's something that requires constant vigilance. The three elements of the Bosselman and Cayley's work of planning, meaning something, of the environment as a consideration in planning, and a state role in planning will probably stay with Oregon for the foreseeable future. Thank you.
Thanks so much, Ed. We're going to depart a little bit from our schedule among all the other hats that Ed wears. One is adjunct professor, and he's got to fly back to Oregon to teach a class today, Ed. So whereas we would like for you, for the rest of the conference, to provide written questions, and they will be collected, and we will deal with them at the regular Q&A period, I'd like now to ask that if anyone has any questions about what Ed Sullivan presented, to please ask them now, and he will address them briefly. Thanks.
You stated that all plans are reviewed every 5 to 15 years. What determines that 5 to 15 year span? Is it haphazard, or is there a growth component? Or?
The idea originally was to group cities and counties together so that you had a regional review of plans. My remarks could not say is that the periodic review problem has been lack of funding. So most of the review goes where all the action is. It's mandatory in the Portland area every 2 years, so that you have to look at your growth patterns and see whether you want to grow up or out. And any other area of the state where there's a lot of activity, then you've got to do the 5 to 15. But we have, one of our problems, that plans from the late 70s and early 80s in central, coastal, and southern Oregon are still in place and have not been reviewed because of money. Yes?
You mentioned destination zoning.
Destination resorts.
Does that cause as many problems as
Yes.
not familiar as I can imagine?
Yes. Transportation is a big issue. And what do you do with worker housing? All right. Everybody wants to have a destination resort if you're outside the Portland metro area. It's a big economic generator. On the other hand, it creates so many problems in terms of public services and facilities because these are outside urban growth boundaries. So you have to do sort of the same considerations as if it were an urban growth boundary. And you got to deal with how are you going to get people to live and work nearby without spending a lot of time getting there.
And how do you deal with, if you turn down somebody's request for that zoning, how do you deal with it compensation-wise? I would think anybody that's got a mountain view or a coastal view or something special, they don't get the zoning they want. Well, you did it for this guy, you should compensate me. You're not going to do it for me.
The answer is too bad. I mean, there isn't any compensation.
You made a distinction between intensity and density.
Yes.
And I was curious about your definition of intensity or what it regulated.
Intensity has to do with higher concentrations of commercial and industrial use in the same area. One of the phenomena that we have in setting an urban growth boundary is efficiency of land use. So it's an effort to get at sprawl. So what we try to do is to concentrate our commercial and industrial uses and make smart use of the land. Yes, sir.
Water is a big issue in the West.
Absolutely.
It's a big issue in Hawaii and many other areas.
Yes.
How does that impact on your planning in the long term?
The question is about water. Inside where most of our population is, which is the Willamette Valley from Eugene to Portland, we don't have a real water problem. Where we do have a water problem is in central and southern and eastern Oregon. But there's not an awful lot of growth there right now, so we fudged, gotten by it. Dan?
Ed, you know, one of the problems I understand in the program is how you decide to expand the urban growth,
Yes.
how you monitor it.
Yes.
I understand the legislature a couple of years ago passed a new method of doing that, negotiating out the urban growth boundary changes in Portland among the different counties. How is that working?
Not extremely well. Here's the problem. We have a goal, Goal 14, which has 7 factors for expansion or setting of an urban growth boundary. 2 of those relate to need, population and industrial and other land needs. The other 5 have to do with the location of the boundary. If you have the need, how do you expand the boundary? We also have the legislature involved, setting priorities, using the land that's already chopped up first, and using as last priority virgin farm and forest lands. The problem is, how do you meld those two? If you ever have trouble sleeping, take a look at a case called 1,000 Friends of Oregon versus LCDC, in parens McMinnville. It is a 62-page opinion trying to make sense of the overlay of the goal and the statute. And what I think will happen is that the legislature will come back again. And the problem that I see is it may make it too easy to expand urban growth boundaries. We'll have to see. Patty?
Explain a little bit more about the big look and what it was intended to do and why it wasn't successful, and whether or not you think that in these economic times the state's going to invest in revisit.
The big look arose out of 2 things. One, pressure by the American Planning Association, Oregon chapter. I was the legislative head of that. And the passage of Measure 7 and 37. We felt we needed to take a look at our system and see if we couldn't rejigger it to bring it into more modern thinking. Nirvana has occurred. Every private acre of land in the state has been planned and zoned. But how do you keep up with changing times? That was why we thought we needed it. And the investment is worth it because otherwise you're going to have more 37s coming down the road. And there are other efforts to have the legislature approve administrative rules, things like that, which are backdoor ways of getting at the program. The investment is necessary. It was badly done because those who ran the big look tried to script the program and to get a preferred result, and it was a disaster.
You mentioned the difficulty in getting some communities to accept higher
Yes.
density. I work with a lot of local officials who seem to spend most of their time avoiding increases in density.
Right.
So how do you go about, in a goal-setting fashion, identifying what is a desirable density in an area?
We have administrative rules for the Portland metropolitan area, which we call the 6-8-10 rule. Depending upon the distance from the central city, Portland, you either have to have 6, 8, or 10 units per acre, mandatory. And LCDC can't acknowledge the plan unless it has that overall density achieved. And we also have what we call the 50-50 rule. 50% of the new housing either has to be multifamily or attached single family. Anybody else? Thank you. Been a great audience.
What a terrific start to the program. Thank you so much, Ed. Hope you make your plane. Flying is stressful enough without having to cut it a little short. Hopefully the expressway will be relatively open. Getting back, As before said, the Quiet Revolution did all begin in Hawaii. So let me take about 3 minutes right now, and only 3 or 4 minutes, because nobody has copied Hawaii for some reason or other. And so there is nothing to look at in terms of who has replicated. It was an odd situation in Hawaii because, first of all, we were a royal kingdom more recently than anywhere else in the United States. And so there was a tradition of central control that most folks are willing to accept. We also have an extremely abbreviated and simplistic local government system. We have four counties. We have no special districts, we have no cities, we have no villages, we have nothing but the 4 counties. In other words, regional government writ large. The region stops at the ocean, so there's not really much concern about any overlap. So for those reasons, we had a system which evolved in which there was really a lot of statewide overall general control. Hawaii passed a land use law in the 1960s which created a land use commission appointed by the governor with the advice and consent of the Senate, sometimes advice, sometimes no consent. That's another issue. And you all know what that's like. After all, I grew up in Chicago, 63rd and Kedzie, St. Rita's Parish. I'm well aware of what goes on in the city, usually. Been following it with great interest, but from a safe distance over the last 30 to 35 years. And the Land Use Commission had its first duty to divide the entire state, or to classify all lands in the state in one of 4 districts: conservation, agriculture, rural, added a few years later, and urban. Only in the urban district do the 4 counties have traditional zoning land use control. And that percentage of land out of the state's land represents less than 4% of the land area of the state. So that the counties only really control urban development, as you all would define it. Over 50% of the state is classified agriculture, and just under 40% is classified, just under 50% is classified in the conservation district, in which virtually no development of any kind is permitted. And then a very small percentage, less than 1%, is designated rural, where the large lot development tends to occur. For a variety of reasons, not used very much because the ag district is shot through with some exceptions that permit certain large lot developments, mainly because we've never defined farm dwelling. And so we get these so-called fake farms where we have 2-acre developments in a row of macadamia nut or coffee trees, and the rest is a high-end several $million-dollar home. So these are the minor things, however, because how has it worked? Well, the truth of the matter is it's worked extremely well. If you look at the map of land use in Hawaii in the first annual review in the late 60s, about 5 years after this act came into play, and you look at the land use pattern map today, they are not identical, but very, very similar. Ag and conservation still represents essentially the same percentage of the state. There's a bit more rural. There's a lot of growth in the central region and in the far east, western regions of Honolulu, where new communities were planned, the first being the Mililani town and the second being Kapolei, but always expected to be there. So on the whole, the system has worked extremely well with respect to a statewide system of land use control. What has not necessarily worked well is relatively minor in the scheme of things, except in Hawaii, which is the level of detail in which the Land Use Commission now investigates precisely what a landowner plans to do with his, her, or its property before processing what we call a boundary amendment. Think a zoning change for all practical purposes, reclassifying land from either conservation or ag to urban. They've gotten into detail, which the statute never contemplated. And has recently engaged in the regrettable practice which Illinois has done for years as well, which is to revert land to its previous classification without a whole lot of investigation in the event of not meeting a condition which should never have been attached to the reclassification in the first place. But aside from Oregon and as Ed Sullivan noted, Florida, very few states have adopted anything remotely like a system-wide total taking back or substantial taking back of the control of zoning. And Florida has become slightly fractured. Now, I will leave this to our next panelist, Nancy Stroud. She has been practicing in the area of land use with two firms for a long time. The present firm bears her name. She also serves on the American Planning Association's Amicus Curiae Committee and its Legislative and Policy Committee, and is active in a number of other things in Florida. But one of her larger claim to fame, and you will see this as a theme which runs through the program, is she is also an ex-associate and partner of Fred Bosselman. Nancy?
Good morning. I want to thank the John Marshall Law School for putting this program together and giving me the opportunity to look back on Florida's history of growth management to try and understand what happened this year. And also to really acknowledge the legal scholars who have made land use so much more sophisticated, I think, in Florida and really nationally, including David and Fred, Dan Mandelker with his work in comprehensive planning, all of whom have greatly influenced the progress of growth management in Florida. And really directly, as a result of the Quiet Revolution, Fred Bosselman in 1971 was asked by the then governor, Governor Askew, to come and meet with a task force that he had put together to look at the state of environmental protection and land use in Florida. And that task force recommended a change in the legal system in Florida that essentially would adopt the American Law Institute Model Code, Chapter 7. And lo and behold, it was adopted the next year. This was in a state which was the very last of the 48 states at the time to adopt the Standard Zoning Enabling Act. Came very late to zoning in the states. And yet, when it adopted that act, there was 1.8 million people in the state. By the time it adopted Article 7 of the Model Code, there were 6.7 million people in the state, and it was the fastest state growing in the country. So it was really perfect timing. It was a circumstance that I think that Ed Sullivan mentioned, the good luck. Florida at that time and still is, I think, one of the most fragile ecologies in the United States. It has coral reefs, it has the Everglades, it has 700 miles of sandy beaches. It's really an extraordinary geological place. And at the time that the Model Code provisions were adopted, it was undergoing an extreme drought. So, as many of us heard, there's, nobody wants to waste a good crisis, and Governor Askew certainly did not. So, in 1972, the state laws were amended by the Florida Environmental Land and Water Management Act to adopt two components of Article 7, which included the areas of critical state concern component, which protects important designated areas, and developments of regional impact, which control certain types of development activities. I won't go into a lot of that process. I will state, though, that Tom Pelham, who later became the Department of Community Affairs Secretary for a total period of 8 years, very influential in Florida, wrote a book after 5 years of the implementation of the act, and noted that in the first 5 years, 269 developments of regional impact had been applied for. A huge number. Of course, remember, it was in a huge growth state. And of those, only 23 really came into a process of appeal where it had to come up to the state level for negotiation. And 17 of those were negotiated to settlement. So it was a very active time. There was a lot of development being reviewed, and there was a lot of state activity and negotiation and review and approval of those developments. The key component in those two programs was the operation of the regional planning councils in reviewing what heretofore had been local zoning kind of decisions, and the ability of the state to appeal and go through an administrative process to ensure that development that occurred in the critical areas or as a result of the DRI process looked and took care of the impacts, the regional impacts of those large developments. So also in 1972, the state adopted the State Comprehensive Planning Act, which created a mandate to adopt a state plan which was anticipated to be a plan with goals, objectives, and policies, sort of like Oregon's state goals and policies. That plan took about 6 years to prepare. And unfortunately, during those 6 years, there was a total lack of momentum. When it finally came back to the legislature for adoption, it had grown to 200 and some pages, lots of detail, and the legislature just threw up its hands and said, we don't like this at all. Let's just stick with the critical area and DRI process. Time passes. The legislature is still concerned about growth and the management of growth in Florida, and it adopts in 1975 the Local Government Comprehensive Planning Act. And this is the Comprehensive Planning Act that required every local government to plan, every city and county. And it set out the contents of the plan, including several elements addressing conservation, addressing land use, and various components of planning. It was a good start. It actually went beyond the Model Act because the Model Act had encouraged planning but had not mandated planning. As a result of this act, also, Florida plans were given the status of law. And critically, all development permits and all development regulations that were adopted by local governments had to be consistent with the plan. So the plan had primacy. It was something that was supposed to guide the future development of the community. What happened here? I think the short answer is that the implementation of that act was abysmal. Local governments, many of them, did try to plan. It took years and years before all of them had plans. There wasn't a very good review process for ensuring that those plans had quality. And so Florida continued to try to improve the system. In 1980, the legislature adopted the Regional Planning Council Act. This required all regional planning councils, which covered the state, to adopt regional policy plans. And this was another attempt to try to get local governments to think more regionally. It was also an attempt to try to get the critical area and the DRI process to be implemented in terms of a regional context. Nothing to this point, except the critical area and DRI process, really got to the local day-to-day routine of planning and zoning. And the real revolution happened in 1985, which I guess is about 25 years ago. Seems like yesterday because that's when I started really becoming involved in the Florida process. And this is the act that I think really changed Florida planning. It went beyond the initial 1975 act. Still required comprehensive plans from everybody, still required content of those plans, but it included a mechanism to make those plans meaningful and make them accountable for regional and statewide issues. And the state set up a fairly complicated and somewhat expensive process for reviewing each plan, having an administrative procedure with an easy access for citizens or anyone to challenge those plans, to go to an administrative hearing officer and through a quasi-judicial process, figure out whether those plans really were in compliance with the state law. And that's what Florida's been living with various adjustments for 25 years. Over these 25 years also, the DRI process has been adjusted. At one point, more developments, types of developments were required to be reviewed. And another point, the threshold of intensity at which those developments were to be reviewed have been adjusted up or down. But over the 25 years, there's basically been a fairly accepted, if not completely smooth, process for local planning that has meaningful state and regional review. The kinds of things that happened over the 25 years that led, I think, to this year's next revolution revolved around several issues. One is the infrastructure issue. Florida is not alone in having the problem of keeping up to date the infrastructure with the growth. And because of Florida's extreme growth, the infrastructure problems were particularly difficult. The part of the comprehensive planning process that was intended to address this was the concurrency mandate. And that concurrency mandate said that new development must take care of its infrastructure needs at the time that the new development came online. And this covered various public facilities, including water, sewer, stormwater, transportation, which really became the critical issue, and eventually, over the years, public schools were added to the concurrency mandate. Transportation concurrency issues really have dominated the system in the last 10 years because the problem is that there's never enough money to build the transportation facilities that are required. The states never provided the money. The local governments don't have the taxing power or the political will to provide the money. So the result has been that developers have been pressured to build all of the infrastructure. And developers go to the legislature and complain about that. The adjustments over the years have been made so that downtown areas could have some exceptions. Adjustments were made to try to make it easier to build in already urbanized areas with the idea that at least if you got more density in the urbanized areas, there'd be more ability to do public transit and not rely on road building. Another issue was the consistency issue. Local government actions and regulations were required to be consistent with the plan, and this was very meaningful. And the legislature really did not mess with this mandate. And in fact, the judiciary in Florida has really been important in upholding that mandate and upholding the primacy of the plan. There's no deference to local governments in determining whether a development order or regulation is consistent with the plan. The courts have sort of maintained their ability to read the plan and say whether or not, according to the court, consistency has been followed. And the courts have enforced the mandate such that, at least in one important case, a developer who had built apartment houses and was later found to have been issued a permit that was inconsistent with the plan was required to tear down those apartment houses. So it's a very serious and very enforceable mandate. Other issues had to do with consistency between local, regional, and state plans. Theoretically, the system is set up to ensure that consistency. In fact, the state plan has never been very meaningful. There have been several attempts to create a state plan that was meaningful, all of which have failed. The regional plans are a little bit more meaningful, but the regional planning councils responsible for them are very poorly funded. So it's a nice theoretical construct, but not really well implemented. One other really important issue has been the issue of home rule. The mandate to plan and to have meaningful plans and to have zoning that's consistent with the plan has been a constant irritation to local governments. It's easy to understand. Although on occasion they will admit, local officials will admit, that it's sometimes been very helpful to have the state government able to say, no, you have to do the right thing. So they can do the thing that's politically expedient, knowing that at some point they can be, held accountable and made to do the right thing. But it's meant that the process has been full of conflict between locals and the state. And it's also meant, I think, that there hasn't been a huge buy-in by the local governments to the system. Originally in 1972, when the Elms Act was adopted, local governments stayed neutral. Home builders hated it. They tried to, not let it pass. This year, in 2011, the situation was pretty much the same, except we have, after 25 years, a new governor and a legislature that is very much a one-party legislature, and a legislature that has term limits. So the new Senate and House members basically know that they're there for a very short time and then they're gone. And the institutional memory about why planning is important and what happened 25 years ago is simply not there. So what happened this year? This year, Florida enacted a new governor, Governor Scott, who actively campaigned against planning, saying that comprehensive planning in the Florida system was a jobs killer, and that if he was elected, he was going to get rid of it. And he was elected. He spent a huge amount of his own money. He ran against what I think was not, and obviously was not a very strong Democratic candidate. And in the same, at the same time, the voters had been presented with a constitutional amendment that would have allowed them to require every comprehensive plan amendment to be taken to referendum. And that had energized the Chamber of Commerce, the home builders, and even, the Planning Association to say that's a terrible idea and we should not allow that constitutional amendment. And the amendment failed. But I think it created this excuse to say that planning is the enemy. And if we really wanted to get out of the home building crisis that exists in Florida, planning had to be done away with. So indeed, there were major changes as a result of this last legislation. What changed? Well, the one thing that did not change, and I take some hope from, is that the requirement of a mandated plan continues. Every county and city has to have a comprehensive plan. Also, the requirement that development orders and regulations have to be consistent with the plan continues. And an administrative process to challenge whether a comprehensive plan is in compliance continues, although in a very weakened state, and in a state that really relies on citizens and third parties to enforce it. The area of critical state concern law continues. Although it has to be said that it hasn't been used that much. There's really only one significant area of critical state concern in Florida, and that is in the Florida Keys. But what has happened is that there's been a real return to home rule. The slogan, I think, that we kept hearing during the legislative session was, we have to let cities be cities. And the explanation was, 40 years ago, our cities were very immature. They really didn't know how to plan, and we went through this process of having them learn how to plan. Now they're doing great. Now they have a plan. We can let them go ahead and just, do their thing. So there's really no need for the state to have much, if any, control over the cities. And indeed, the state role has been reduced probably by about 80%, so that for most plan amendments, the state gives comments, but does not try to determine whether the amendments are in compliance with the statute. The administrative rule that provided the details about how to do a plan and how to amend a plan was rescinded by the legislature. The legislature also did away with the Department of Community Affairs, which was the department that had the responsibility for reviewing and determining whether plans are in compliance. They left a small component of the State Land Planning Agency in a division in what is the new Department of Economic Opportunity, which probably gives you an idea of what kind of plan review is going to happen. And the legislature also made optional concurrency for traffic, for schools, and for parks and recreation, so that cities and counties now have the opportunity to say, we don't want to do concurrency anymore, pass an ordinance without even amending their plan, and lo and behold, it'll be gone. There are a lot of other details in the process that I will try to explain more in the paper for the law review. But I think there was a kind of perfect storm in 2011, and a good excuse. It's the bad luck part of the Florida story. We had good luck for 25 years with very strong leadership on the part of our governors who supported the planning system and really worked hard to make it work. And we have, in my opinion, kind of the bad luck of economic problems and a new political reality in Florida, probably in many other states, possibly the nation, that's going to be much more critical about having active state and regional planning efforts ongoing. Oh, thank you very much.
Getting back to our original theory on how to deal with questions, if you would write down questions, and one of the editors of John Marshall's Law Review will be circulating among you to take them. If there aren't any written questions, we'll take a few from the floor, but we'll do the written ones first. As you consider your questions, written or oral, you might consider this brief story wherein an Irishman was touring France, and he entered into a little bar in rural France, and there at the bar was a Frenchman drinking whatever Frenchmen drink at that hour. It was early in the afternoon, and two magnificent hunting dogs at his feet. And the Irishman, being somewhat of a hunter, approached the Frenchman and said, "Those are magnificent animals you have there. I'd like to pet them. Are they gentle?" And the Frenchman looked over and said, "Oui, monsieur, they're very gentle." The Irishman reached down to pet the dog. Immediately, one dog took his foot, the other took his arm. He was badly mauled. And as he was looking up from the ground in some pain, He said, I thought you said your dogs were gentle. Then the Frenchman said, well, oui, monsieur, indeed they are, but these are not my dogs. So as you ask the questions, be careful on a follow-up and see that they come in as you would like the answer made. Do we have any written questions? Well, that didn't work very well. Are there any questions that you would like to ask of either Nancy or myself at this time? Yes, Patty Salvo.
I was writing, but it was taking too long, sorry. So, Ed Sullivan says that, in his opinion, there would never be a frontal attack on Oregon's system. And I wonder if he would be as confident saying that if he heard your presentation, because I'm not sure that anybody really expected the outcome and the campaigning that went anti-planning in Florida. So I guess my question is, in looking at which level of government, if we relied on the state government for so long and we felt that that was a great model, but if it is subject to the political whim for the entire state, is it better to let all the different experimentations in democracy at the local government level fester and have greater control there and more rule as you suggested, because maybe all wouldn't be lost, as opposed to putting all our eggs in the basket of state level government?
That's a good question. In reading through the history of Florida growth management, you could see around the 1980s, there was a concern that the critical area process and the DRI process really wasn't going to have the long-term impact that a really good comprehensive, integrated state comprehensive planning process would have. And the idea was, instead of doing the ad hoc designation of critical areas and having the state come in, or the ad hoc review and approval of certain types of development, it would be much better to have a solid, integrated system where locals plan, the regions plan, the state plans, and somehow they're all coordinated. And I think theoretically it sounds wonderful. You know, we're all looking at the same stuff and implementing the same stuff. And so there was a real shift to that and a real concentration on that. And I think rightly so, because that's really what has made the change in Florida. The critical area program and the DRI program got a lot of public attention, you know, and it was not easy. You know, there's a lot of gnashing of teeth that went into making that work. But the real work came at the local government level. Now, I don't think that the local government level can do it by itself, though. And there has to be some sort of meaningful relationship to the region, at least to the city on its boundaries, which the region was supposed to try and work through those intergovernmental problems. So I guess we'll need to see. I think what results from taking away the state role is to increase the judicial role. And the judicial role has been very important in Florida, as I mentioned. There have been some really good cases that have upheld the necessity to plan and to plan well. But even in the last couple of years, there have been some quite bizarre cases coming out of Florida. And that may just be some quirk, and it's you know, it's not going to continue that way. Part of the reason I think the judicial system was so supportive of the planning system is because the planning system did evolve over many years, and the governors who were in office at that time had a lot to do with who was appointed to the judiciary. Since Bush, Jeb Bush, and you know, our new governor, those appointments, the legislature's been trying to take back the appointment ability and messing with the new governor and legislature tried to do a kind of Roosevelt thing and increase the number of Supreme Court justices with the idea that they could increase their influence over the judiciary this last session. So, so I'd like to be able to count on the judiciary to continue to make the process work, but that also is something that could be changed.
I should add that Hawaii did eventually do a plan, but like a lot of things in Hawaii, they did the plan after passing the laws. And then put the entire plan for the state in the statute, not called for it, but wrote the entire plan into the statute books. So it's a little bit unusual, a little bit extreme. We tend to do things a little bit over broadly in Hawaii when we get to a certain area, and that's kind of the way it goes. We are a little bit ahead of schedule. I should just add with respect to my home state that we have not litigated the statute once. In 40 years, no one has challenged it. There have been little side things that have come about over procedure, whether a land classification is quasi-judicial or legislative. We now have a Hawaiian traditional and customary rights impact statement that our court requires before any reclassification. We have a rather substantial indigenous population which has not got tribal status. That's another story altogether. About 300,000 of our citizens claim some out of 1.2 million, some Native Hawaiian status, and our Constitution provides that Native Hawaiians are entitled to go on any land in the state that is not substantially developed, government-owned or not, to exercise traditional and customary rights, subject to reasonable regulation by the legislature. Sort of a guarantee that if you are Native Hawaiian, you will not be arrested for trespass by going onto private land in order to exercise your rights. I have gently kidded my wife that the reason I married her is that I can go at her side and walk anywhere I want to so that I can take advantage of her traditional and customary rights, whatever those are. It's a terrible death to be talked to death, and again, quoting Mark Twain, this is your first opportunity to escape. We'll reconvene at 10:50. If anyone needs more on Hawaii, I have written a small thing on Hawaii that's finally in its second edition as of last year. It is good for insomnia, if nothing else, if you're having trouble sleeping, and so I'll put these brochures about the book up on the table. Thanks, and we'll see you back in 15 minutes when we return, 20 minutes when we return to Quiet Revolution Country.